Thank you. You may be seated. We have one case on the docket today, Anthony Cesar versus State of Florida. Is the appellant ready to proceed? You may.
May it please the court. Michael Efferman on behalf of the appellant Anthony Cesar. I'd like to reserve 5 minutes of my time for rebuttal. There are two claims raised in the briefs, and I'm hoping to address both claims during this morning's oral argument. I'll begin with the first claim, which is the JOA issue. The JOA issue is an issue of statutory construction, and the case law in this state is clear that when a court is conducting a statutory construction analysis, the court should afford the statutory language and terms their plain and ordinary meaning, but the court must also give due regard to the context within which those terms are used. The statute at issue in this case is 775.21 subsection 10b, and that statute makes it illegal for a sexual predator who works, whether for compensation or as a volunteer at any, and then it lists a number of organizations after that where children congregate. The organizations include a child care facility, a school, a business, or as relevant to this case, a park. So I submit that when you give this particular statute its plain and ordinary meaning, and when you look at the terms that are relevant in context and compare it to the facts of this case, my client's conduct does not fall within the purview of the statute.
Well, why, aren't you reading the act to be for? Isn't that what it comes down to, that you give at a different meaning than its normal dictionary meaning?
I don't think so, and I understand that's clearly what the state argued and what the judge ultimately found, that geographic meaning versus working for a particular business. But again, I think when you step back and you look at all of the terms that are used in this statute, the legislature said if you work at one of these places, one of these organizations, a child care facility or school, and you do so whether for compensation or as a volunteer, the legislature is in context clearly talking about someone who is affiliated with that organization. I think this example of a child care facility or school is pretty clear. I don't know how someone could be charged with this statute without actually being a volunteer or a worker for that particular school or child care facility. But even if you look at a business where children congregate, I was thinking when I was growing up, a place that children would congregate is a roller skating rink. I'm not sure if kids go there anymore. But if the facts of this case were that my client was going to a roller skating rink, and he wasn't volunteering at the roller skating rink, didn't have any affiliation with the rink, he wasn't working for the rink, he was just at the roller skating rink, and while he was there, he was offering to teach other people how to roller skate, I submit that that wouldn't fall within the purview of this statute.
Isn't that the more as far as what work means? And it wasn't argued below that this wasn't work. It seems like what was argued was just the at or for. So are you making an argument that's not preserved?
No. The argument that's made is that my client's conduct doesn't fall within the purview of this statute. I think the court recognized that, and Judge Allman even said, and this is page 98 of the transcripts, well, it seems to me that the two of you have identified the same issue that jumped out to me when I was preparing for the case. And so the question I had was, what was the conduct the legislature was trying to prohibit? So the issue is, with this language, what is the legislature trying to prohibit? I submit the legislature is trying to prohibit people from working for an organization or volunteering at an organization where children congregate. They're not trying to prohibit, at least by the language that's currently in the statute, someone from going to a place where children congregate. They could do that.
Let me, if I decide to, earn money, make my living by giving tennis lessons, and I do so over at the city courts, and I do it all the time, a few times a day, I give lessons and they give me $20 for each lesson. Without waiving Judge Bilbrey's concern about whether this is the same as being affiliated with it, is that work?
Is
what I described, is that work?
But it's not work at the organization.
It doesn't say at the organization.
It does.
It just says, well, you're right, it does say at the park, but I am at the park.
Again, I submit that under these, the legislature could have broadened the terms. So for example, if my client was just playing tennis at the park, and there was someone at the court next door, and instead of saying, hey, I'll offer to give you a free tennis lesson, he just said, come play with me. Would the state be saying that that conduct would fall within the statute?
I doubt it, because that's not what happened here.
Well-
He did affirmatively offer to give tennis lessons, as opposed to just, hey, let's play tennis, and here's a couple of pointers.
He did, and again, I submit that there is an argument. My client can win in one of two ways. One would, if you agree with me, that within context, the plain and ordinary meeting means someone who was affiliated with the organization. Obviously, my client can also win under the rule of lenity. And I think that Judge Allman's comments during the proceedings below established that at the very least, this is an ambiguous statute, or there's a viable reading of the statute that would include someone that must be affiliated with the organization in question. So for instance, on page 99, Judge Allman said, right, but I mean, there is an argument to be made that working there means that they are somehow affiliated with the park. He went on to say, when he was ultimately denying the motion, that while I think the defense argument is very well presented and may have some merit, those findings alone establish that there is a viable reading of this statute that would mean that you must be affiliated with that organization. Again, the legislature could change the language in the statute and apply to anyone who's present at the park where children congregate.
Your interpretation under either theory then is that he had to have a stamp of approval from the park.
An affiliation with. I mean, I think that's what was argued below, and I'll stick with that. I do note also that there is a
Like
statute.
the park issuing an advertisement, free tennis lessons every Monday, Wednesday, and Friday at 3 o'clock with instructor, Bob Smith.
Sure. That would clearly fall within the purview of the statute. I agree with that. There's also a statute that could apply under these facts. The state chose not to charge it. 856.022, it's referenced in the pleadings below or during the trial, is entitled loitering or prowling by certain offenders in close proximity to children. And sub 3 says that a person who's a sexual predator commits loitering and prowling by loitering or prowling within 300 feet of a place where children normally congregate. The state could have, the documents in this case reference two potential statutes that the state could charge with. One is 775.21 and the other one is 856.022. The legislature already covers conduct like my client's, but when in this particular statute with that language, and again, they could have just said works at, but when they add in the idea of compensation or volunteer, that is clearly adding in, or at least there's a reasonable interpretation that is adding in this concept of an affiliation with that organization. And absent that, and there's no dispute in the record in this case that there is no such affiliation, I submit that the rule of lenity would apply and the judgment of acquittal motion should have been granted. Let me briefly address the second claim. The second claim concerns the trial court's condition of probation that said that my client could not seek modification until he had served 5 years.
But that wasn't exactly what he said, though. I mean, he said, I will, however, leave room for the defendant to apply for a step down from sex offender probation to regular probation after the 5 years have been served. So, I mean, it doesn't say you can't or there's no early term or anything like that. How does that language, I mean, it seems different than the Murphy and Hops case. How does that language impinge on the executive authority for DOC?
Well, and there's two statutes at issue. There's both 948.04, which is the probation officer's authority to recommend early or modification of probation at any time, and there's 948.05, which is the court's ability to modify probation at any time. So different from the two cases I've cited because those said no early termination versus this is a limit on having to serve 5 years. I don't think that's your question, Your Honor, but I think I've addressed that in the briefs. There's no difference between, if the statutes don't allow you to curtail the at any time language, then whether you say no early termination or you must wait 5 years, clearly both would curtail the language in the statute. If the issue is that, oh, Mr. Caesar can apply himself, but nothing prohibits the probation officer under 948.04 or the court from under 948.05 from modifying at any time, I submit there's a couple problems with that. Number one, The order of probation specifically says the language you just recited, Your Honor, that he cannot seek step down until he served 5 years. No reasonable probation officer is going to read that and think that I still have the authority under 948.04 at any time or prior to that 5-year mark to recommend early termination. So at the very least, I would ask this court to direct that the judgment be amended to reflect that if the judge is only intending to prevent Mr. Caesar from being able to apply, but nothing prevents the probation officer from being able to apply prior to the 5-year mark, okay, I can understand that argument, but I submit again, as is, no probation officer is going to read that language and think they still have authority under 948.04. But the other problem is with 948.05, that's the statute that allows the court to modify at any time. I don't see how, I don't know what vehicle a court would ever have the ability to modify probation or terminate probation unless someone files a motion. And 99% of the time, I submit that's going to be the defendant. The defendant may do so and say that my probation officer is recommending early termination, but the court on its own, that I'm not aware of at least, is not calling up previous cases from its docket and saying, you've already served 3 years, I know I gave you 10 years, but I'm thinking about modifying. So again, in reality, if you are saying that the defendant has no ability to seek early termination or modification until the 5-year mark, that limits the judge's authority under 948.05 because a judge can do that at any time, and the only vehicle that a judge would be able to do that is a defendant filing a motion.
Counsel, should we, the case law, none of it has anything to do with modification, just termination. Does that make any difference, or
No.
are you trying to extend those cases?
The statutes talk about both modification or termination. So I think it's the same principle. In the other cases, they said no early termination. So presumably, if you can't seek to modify your probation as a step down from sexual offender probation to regular probation, that would also mean you also can't seek early termination. So I think the same principle applies regardless. I'll reserve the rest of my time for rebuttal. Thank you.
Good morning. May it please the court, my name is David Welch, and I represent the state of Florida on this case. On the first issue, appellant was talking about legislative intent. And honestly, you just have to go earlier in the statute. The legislator lays it right out in 3B5. It says specifically, the intent of statute is prohibiting sexual predators from working with children, either for compensation or for volunteer. So it's not preventing specific sexual predators for specific employees of whatever business. It's sexual predators in general. And as your honors were talking about earlier, the laws of statutory construction, we got to read the plain meaning of the statute. And it clearly says a sexual predator who works, whether for compensation or as a volunteer, at any business, school, park, whatever. And the definition of at, for Merriam-Webster, is used as a function word to indicate presence or occurrence in, on, or near. So clearly, the intent of the statute is to prevent sexual predators from working with children. And here, I think there's no doubt that the appellant was trying to build a business. Multiple witnesses testified that he was in the park soliciting clients, offering free lessons for the stated purpose of building up a tennis instructor business.
Would you agree if he was just there playing tennis, that wouldn't be work? I mean, you might say, I need to work on my game,
Right.
but that's not actually work if he was just there playing tennis.
Yes, yeah, I would agree with that. If he was just there playing and someone walked over and hey, can I get next game or whatever, that's not work, and that potentially would be the other statute that appellant referred to about the loitering around children or whatever. But in this case, he was actively soliciting both minor children and adults to say, hey, I'm trying to build my tennis business. I'm going to offer you a few free lessons. And then I believe the deputy testified that the appellant stated that he was volunteering with an organization that was, their stated goal was to, I guess, spread tennis, get more people interested in the game.
Where do you draw the line, though? What if he was, picking up trash, or he went to pick up all the tennis balls on the court, just gratuitously, he didn't have any kind of organization. He clearly didn't work for the Park Service or for Southwood. He just decides to go and, pick up everybody's tennis balls. Would that be working there? I mean, where do you draw the line as far as what work is?
I mean, that is an interesting hypothetical, because you could say he's doing a service, if you will, for the organization. I mean, obviously that's not what we have in this case. And for another example would be, say I owned an ice cream truck, and I drove it to a park and I was selling ice cream cones to kids. I'm not working for the park at any means, but I am working at the location of the park, selling goods to children, which, as I stated, the stated purpose of the statute is to prohibit sexual predators from working, either for compensation or as a volunteer, with children. I think it may come down to how often he was doing it, if it's considered work. Like, if he's just in the park picking up trash, you know, I'm not sure that many people would consider that work, but, you know, if you're doing it every day, you know, you're starting to toe the line. But again, here, we don't have that, because his stated purpose, according to the testimony of trial, was he was trying to build a tennis tutor or tennis instructor business at the park.
If the purpose of the statute is to keep them from working with children, that raises a couple of questions to me. One, which is the point that Mr. Ufferman made, that there's a statute already that prohibits being at a place, whereas this one prohibits working at a business, which he was not, according to the appellant. So there's that, but the other that occurs to me, well, go, if you can address that.
Well, I mean, it wouldn't be the first time that a single course of action could, in theory, violate two different statutes. And then it would be up to the prosecutor to choose which theory of the case they wanted to proceed under, or potentially if they proceeded under both, you would end up with one of them being dismissed after the verdict. So.
All right.
And did you have a follow-up question to that?
No, go ahead.
Okay. And then moving on to the second issue in this case, the conditions of probation, as Your Honor stated, the judge basically said, if you no violations, go ahead and apply, you know, you can go ahead and apply for step-down probation after 5 years. And here, he gave him 2 5-year consecutive terms of probation. And basically, the judge is signaling to him, like, hey, stay on your best behavior. I'm going to give you this carrot. And basically telling the appellant, don't act up for 5 years, and I will probably approve your step-down probation. He's trying to incentivize the appellant. Whereas in the 2 cases cited by the appellant, both of them had the language where the judge put in a special condition that specifically said, there will be no early termination, and that's just not what we have here. Here, the judge is saying, after 5 years, I'll go ahead and I'll approve your step-down if you behave. There's no, and again, it's similar to the first issue, what the appellant's asking you to do is add additional words to what the judge said. There's no prohibiting language in this that says DOC, which is where the case law says that you can't limit DOC's authority to recommend early termination. And here, he's not even speaking about early termination. He's speaking about a modification to go from sex offender probation down to just general probation.
Isn't that termination of sex offender probation?
Yeah, termination of sex offender probation to regular probation, I guess. I mean, I guess we'd be arguing out what the word means again in this issue if we go there. But in this case, the judge, like I said, the judge is just trying to incentivize the appellant to follow his conditions of probation.
Well, I don't disagree with you that it's, you know, maybe a good idea, but doesn't it infringe on DOC's executive authority to make the decision whether to recommend early termination or recommend any modification of probation?
I don't believe so because, again, contrast this to the 2 Second Circuit cases that the appellant cited where the judge in those cases said there will be no early termination. Here, all the judge is saying is, hey, Mr. Caesar, after 5 years, you personally can apply for modification. Nothing in that language prohibits DOC from doing whatever DOC wants to recommend that they would do. You know, I don't know what effect that would have on a probation officer or not. I mean, again, you're basically asking the probation officer to recommend early termination before the second term of probation is even begun, which a probation officer could do, because in this case, the language doesn't actually prohibit them from doing that. It just says, Mr. Caesar, personally, after 5 years, you can go ahead and apply for modification, and the judge is signaling that he would grant it with no violations after 5 years.
You raise an interesting point. There's 2 consecutive 5-year terms of probation. Does that make it problematic in that one term, then basically there's an order of no modification then, that he's got to complete that 5-year term as ordered, no early term, no modification, somewhat implied by what the judge says, before that term of probation even ends and he would begin to start the second 5-year term? I
don't believe so. Because, I mean, look, the alternative would be if the judge just said, I give you 2 consecutive terms of sex offender probation. And so you'd still be in the same situation with DOC where they could recommend early termination of the first term, or they could recommend step-down probation. Because there's nothing in, you'd have to add language to what the judge says to read in a limiting factor here. And there's nothing, I mean, he didn't prohibit Mr. Caesar. In theory, the appellant could apply for modification early. Nothing the judge said he prohibited him. I think the judge was just trying to convey the fact that, like, I'm probably not going to approve it until 5 years, the halfway mark, basically. You know, show me that you've followed your sex offender probation, and then I'll be, you know, again, I'm saying he's incentivizing him to behave for 5 years so he can get a carrot at the halfway point.
Counsel, you did say earlier that you don't know what effect these words would have on a probation officer. And I agree with you, but, appellant says that, look, a probation officer is going to see this and is going to say, oh, the judge has said I cannot recommend, he's not going to get any kind of an early termination or modification, whatever, until 5 years. Can you address that? I mean, how should we take it into effect that there's a possibility that a probation officer could take that view?
I mean, you could argue the same way with, if the judge didn't say anything, the probation officer might interpret that as, because again, we're in hypotheticals, that, oh, the judge doesn't want early termination on this one because he didn't incentivize this guy at all. And again, it's a difference, I think, with the case law cited by the appellant, they're talking about prohibitions on early termination. Here, we're just talking about a step down where the judge is trying to say, I'm giving you sex offender probation, but I'm signaling to you in your favor that you have a possibility of getting to, for your second probation term, regular probation as opposed to sex offender probation with the additional requirements that carries. Unless you have any further questions, the state rests.
May it please the court. Let me briefly address the second claim first. Whether the court was good intentioned or not, what the court did is contrary to what the legislature has said in these 2 statutes. The legislature has said that probation can be modified or terminated at any time. The only exception to that in case law is that the state, as part of a plea agreement, can put in a no early term or no early modification provision, and the defendant can agree to that. But absent that, the legislature is the one that has decided that probation can be modified or terminated any time in these 2 statutes. The defendant doesn't need an additional incentive. The defendant is presumed to know the law, that if he does well, he can go back to the court and seek early term, or the probation officer can recommend early termination or modification. But again, so these oral pronouncements should not be made, and they're contrary to the law. The legislature could change it. The legislature could say, until you serve half of your term, you're not even eligible for early termination.
Counsel, speaking of oral pronouncement, I think it was the Murphy case where the state had argued that, well, you can't raise this by 300B2, and of course, I can see you nodding your head, so you know where I'm getting at. The court said, well, that's because it wasn't orally pronounced, so 300B2 is perfectly fine. Here, of course, we have an oral pronouncement. Does that mean that this should not or could not be raised by 300B2?
Obviously, the other case, Hops, did allow it pursuant through the 300B. It's also a second DCA case. And I think courts around the state have held that 3.100B is a proper vehicle to challenge this, even if it was orally pronounced. And then beyond that, the state didn't raise that issue. They alluded to it, but certainly didn't argue lack of preservation in the brief. So I submit that issue would be waived by the state. Let me quickly turn to the first issue. And I think, again, I'm not going to argue that it's not a reasonable interpretation, that the judge's conclusion wouldn't be a reasonable interpretation. It is, I submit that it is, but I also submit that there's another possible interpretation. I think Judge Allman acknowledged as much when he was talking about this, when trying to decide this. He really struggled with this. He specifically said it wouldn't be the first time that there was some sort of hole in a statute or some unintended consequence, but this could be the perfect example of that. So if there's any ambiguity in the statute, if it's a viable reading that this statute only applies to those who are affiliated with one of these entities, a child care facility, a school, a park where children congregate, a playground where children congregate, then under the rule of lenity, my client must be given relief. Courts in recent months have found that there's holes in statutes and have said that therefore the defendant is entitled to relief and the legislature can address it if they need to. In the Davenport case, this court found that PRR didn't apply to a particular L&L charge. In the James case out of the second DCA, the court said that you don't qualify for sex offender registration if you still owe a fine. The legislature has since addressed that and changed the statute to say that regardless of whether you paid the fine, you must register as a sex offender. So under this statute, the way they worded it, the way they talked about compensation or as a volunteer, and they tied it to these particular entities, there's at least a reasonable interpretation that it must mean someone who's affiliated with one of those groups. Because my client was not, there's no dispute in the record that he was, the judgment of acquittal should have been granted under the rule of lenity. So I'd ask this court to reverse. Thank you.
Thank you, counsel. Thank you both for your arguments. The court is in recess.